Good afternoon. Welcome again to another edition of Florida Appeals Journal. I'm Jennifer Carroll, and today we're going to talk about motions for continuance. This is something in like 35 plus years you see all the time. It is a necessary tool, but again, it has to be necessary. You can't just move for continuance of your trial or your hearing just because you were late in the game, right? And you didn't get everything done you were supposed to. There are a lot of bad reasons to move for continuance, but there are good reasons. You may have a counsel that took ill, a party that took ill, have a problem with an expert witness, could have some discovery issues unresolved that you've tried to resolve, they haven't been resolved. So you have good reasons, but how do you know really when you're going to get a motion for continuance granted? I mean, you got to remember the trial court has, so much discretion in granting a motion to continue a trial. For example, trial judge is, of course, in charge of his or her own docket, right? And has to get cases tried. But you also have to afford, we still believe in due process here. So, and you want to make sure the litigants can have a fair trial, right? So you have to consider if something comes up and the judge has to take a look at it and what standards do you go by. That's what we're going to talk about today. All right. And just remember, as a general rule, if a trial judge denies a continuance, for example, and you're going to make that one of your issues on appeal, what is the standard of review? Well, it's generally an abuse of discretion, but the appellate court has said that discretion is limited. It is not unlimited. All right. So what are the parameters that they're going to look at? Right. The appellate court is going to consider first whether the movement is going to suffer an injustice or suffered an injustice from the denial of the motion. And they're going to look at, how serious it was. And then number two, whether the underlying cause for the motion for continuance was unforeseen by the movement, and whether the motion is based on dilatory tactics. So you can't just drag your feet and then say, oh, I'm just not ready, judge. I need more time. That's not going to cut it. And the appellate court's going to look at that. Number three, whether prejudice is going to fall upon the opposing party if the motion would have been granted. In a really good 50 case, Health First v. Cataldo, 92 Southern 3rd, 859, and that's a 2012 case. So what the courts have held, and this is a really good case out of the second DCA, and that's a 2002. It's a little bit older, but it states some pretty good principles. Faig, F-A-S-I-G versus Faig. That's 830 Southern 2nd, 839. And that's the second DCA. They held, quote, in certain circumstances, the denial of the motion to continue may create an injustice that outweighs the policy of not disturbing the trial court's ruling. And you want to remember that's a strong policy, so you're always going to be running up against that. So it's got to be pretty drastic. Silverman, and that's a third DCA case. That's 514 Southern 2nd, 77, and we'll post these. Quote, special circumstances sometimes exist, however, in which the denial of a motion for continuance creates an injustice for the movement. In these circumstances, this court's obligation to rectify the injustice outweighs its policy of not disturbing the trial court's denial, right? The trial court's order on the continuance. So what are these drastic circumstances that the appellate court is going to consider? Well, one of the big factors is the prejudice, right? The prejudice that the denial of the continuance resulted in for the movement, okay? The appellate courts recognize that if you've got a situation where the party was effectively prevented from presenting his or her case, that's a problem. And that's why in Faig, the court, second DCA, reversed the final judgment and remanded for a new trial on the basis that the wife's motion for continuance should have been granted. Quote, the trial court's denial of the continuance, quote, prevented the wife from presenting any case whatsoever. And another example is lack of counsel. That's going to be probably, that's a pretty common legitimate cause for continuance. Counsel either fell ill or you wanted to get counsel and the trial court wouldn't let you. Because that's very important. You have some pro se plaintiffs who think they're going to be able to tackle a trial. And then as they get closer to it, or their eyes start getting open to say, wait, I really don't know these rules of procedure. I really don't know my way around Earhart's evidence book. I don't know how to really do the objections. And then they may say, oh, I really need counsel here. And that's got to be treated seriously. If they move to continue, they're trying to get an attorney to represent them. And there's a very good case. Again, that's a little bit of an older case, but it's a good one. Barron v. Barron. That's another second DCA out of, that's 06, 941 Southern 2nd, 1233. And there, the appellate court reversed the trial court's denial of the father's motion for continuance, finding that the father was prejudiced by the fact that, quote, he was not a lawyer and thus had, quote, limited ability to make proper objections. The appellate court specifically found that the lack or unavailability of counsel prevented a fair and objective presentation of a party's case. And in that case, Barron, the court recognized that, quote, the right to be heard at an evidentiary hearing includes more than simply being allowed to be present and to speak. I mean, a lot of courts think, oh, that's enough. You got your due process. No. What the Barron court said is instead, the right to be heard includes the right to, quote, introduce evidence at a meaningful time and in a meaningful manner. So the court found that denial of the father's motion for continuance, quote, resulted in him not being permitted to present evidence in a meaningful manner. So that was a great case explaining and really offer an example of when a motion for continuance should be granted. We'll add our case sites to a post, but I think you will find this helpful. It's an issue that comes up very often, and knowing how to handle it, I think would be very helpful to anyone involved in litigation. Any questions, let us know. Again, thank you for your time, and we will see you at the next edition of Florida Appeals Journal. Thank you. Hi, I'm Jennifer Carroll, and I want to thank you for watching our video. You can see more of our videos right here. Or better yet, subscribe to our YouTube channel below so you won't miss a single one.